Thank you. May I ask if there are any apologies for absence?
Yes, Madam Chair. MP Rhoda Crawford asked me to apologize for her absence today.
Okay. MP Julia Cuthberg as well sends her apologies, yes. And MP Morgan, Robert Nesta Morgan.
MP.
And Member Hamilton.
MP Nita Edley, or Nita.
MP
Garvey.
Nita.
Yeah, sorry, can't keep it. MP Nita Garvey, Natalie Nita Garvey.
Very good. All right, let me say welcome to everyone, welcome to members, welcome to our support staff, and most of all, welcome to members of the Jamaica Teaching Council, Jamaica, the JTA, Jamaica Teachers Association. So sorry for that. We're here, the JTA would have sent in a report, and it would have been circulated to members. But before we get into that, before we ask them for their presentation, I would love for President Mr. Winston Smith to introduce the members of his team.
Thank you, Madam Chairman. Let me take the opportunity to greet you and to greet all the members of this honorable body. The team representing the Jamaica Teachers Association today is comprised of Clayton Hall, Deputy Secretary General with responsibility for Members' Services and Industrial Relations, Dr. Mark Nicely, Secretary General, Dr. Garth Anderson, the Chairman of the Salaries and Conditions of Service Committee. I must apologize for the absence of Mr. Jasford Gabriel, immediate past President. And we have with us our President-elect, Mrs. LaSonia Harrison, and yours truly, Winston Smith, President. And of course, Ms. Julianne Mowat, our legal officer. And
thank you so much. We will move now to confirm the minutes of the meeting held on Thursday, April 21, 2022. Minutes were circulated, and I will just go through indicating the page if there are any corrections.
Chairman, you said it was circulated. I happened to have checked my email at 1 o'clock and saw that it came 43 minutes earlier. That certainly didn't give me any time to go through to peruse the minutes, and I'm moving forward to postpone the discussion of minutes today for the 21st for the next meeting, because it's not fair to, well, I certainly can't speak for others, but not fair for me in a busy day to get the minutes so late and expect to come and go through it with the meticulous nature that it requires. So I'm moving for it to be put back to the next meeting. And also urge that the minutes be at least sent a day before the meeting.
All right.
It can't be on the same day. Yeah.
Thank you, Member Brown. We accept your observations. And so I put it to members to delay the acceptance of the minutes until our next meeting, and that we will endeavor to have the minutes sent out with enough time for members to read and to come back. Members?
Agreed.
Okay, we'll move right into the presentation by the Jamaica Teachers Association. Please go ahead, Mr. President.
thank you, Madam Chair. Madam Chairman, the Jamaica Teachers Association is indeed grateful to this honorable body for affording us the opportunity to let our voices be heard on this very important and far-reaching bill. The team representing the JTA, as would have been presented to you before, are here to share with this body the position of the teachers represented by us at the Jamaica Teachers Association. This Jamaica Teaching Council bill, Madam Chair, is a bill that has the potential to transform the educational landscape once passed into law. Madam Chair, we want to make it abundantly clear from the onset that the Jamaica Teachers Association fully support the idea of a regulatory body to further advance the professional standard of teaching and the profession as a whole. The current bill has proposed several changes to the way we operate as members of the education fraternity. And whilst we embrace many of the submissions or proposals in the draft document, we are diametrically opposed to several items in the bill. It is very interesting that since the advent of this bill, approximately 10 years ago, we are still having challenges with some of the contents herein. These challenges are of fundamental importance to us, who will be directly impacted by the bill. It must be noted, however, that we do acknowledge that some amendments from the original document, when it was first proposed, has been made, but still there are areas of grave concern to us as educators. It is to this end that we are here seeking to have these areas amended so that the bill can truly benefit all parties when accepted and is operationalized. The areas of great concern to us, Madam Chair, are as follows: the composition of the board, the fines to be charged, the potential conflict with other existing laws, the complaints and disciplinary inquiries and actions, drafting issues, and last but by no means least, facilitation of early childhood practitioners or VTDI instructors and lecturers. Madam Chairman, the team here today is comprised of educators who will all be impacted by the decisions we make now concerning this bill. Furthermore, future educators currently in colleges and universities are watching with bated breath to see the outcome of our deliberations in order to decide whether or not they should make teaching a career. With this in mind, Chairman, I submit to this Honorable Joint Select Committee that it behoves us to make the right decisions as we seek to preserve, protect, and enhance the professional standard of the teaching profession. Our decisions will undoubtedly have far-reaching effects on the profession and, may I dare say, will determine the quality entrants we will attract and retain in the profession henceforth. As we make our submissions, we must be mindful, Madam Chair, of the purpose of the Jamaica Teachers Association. Enshrined in this document, called the Memorandum and Article of Association of the Jamaica Teachers Association, it speaks to 7 areas. I will not speak to all of them or read all of them, but I want us to focus on number 4. The association is established to achieve any or all the following objectives as may from time to time be reasonably practicable. 1, to promote within its competence the educational interests of the country and keep the public informed concerning educational matters of importance and or urgency. 2, to promote and maintain the unity of the teaching profession, widen the scope of its usefulness, and safeguard the interests of those comprising its membership. 3, to aid the achievement and maintenance of high professional, ethical, and moral standards among all its members. Number 4, to consider and make representations to the appropriate authorities on matters of common interest to its members. And number 5, to afford the Ministry of Education and other educational authorities the benefit of teachers' collective ideas, opinions, and experiences on educational questions and matters of common interest to its membership. Number 6, to keep under scrutiny and consideration the operations of the education laws for the time being in force and all rules, regulations, and policies which govern or touch and concerned education sector arising therefrom, so as to ensure that they serve the best interests of education. Number 7, and I'll stop here for now, to provide social facilities and amenities for the use of its members. Madam Chair, I want us to reiterate and to reinforce number 6, that says to keep under scrutiny and consideration the operations of the education laws for the time being in force, and all rules and regulations and policies which govern or touch the concern of education, the education sector, arising therefrom. It is with this in mind, Madam Chairman, that the Jamaica Teachers Association is here today to share with this honorable body the issues that we have with this bill as it is presented to us, and recommend and suggest, humbly though we say, that the ideas, the challenges that we have be taken into consideration and be accepted as we move forward. Madam Chair, at this time, I will invite, with your permission, our attorney, Ms. Julian Mowat, to present and to make known to us, and to us, this honorable committee, the position of the Jamaica Teachers Association. Thank you, Madam Chair.
Thank you, Mr. Chairman. Please go ahead, Ms. Mowat.
Thank you, Chair and Committee. Just to declare that I am holding for the counsel for the JTA who is unavailable here today, to be here today. As you know, the written submissions were submitted a while ago, so I am standing in to present the oral arguments, much of which have remained as are in the written submissions. As was stated before, the core issues we have identified and will present today concern the board composition, complaints procedure, fines, and the ultra-virus provisions, and I'll take them in that order. I'm never good with this. So in the first schedule, it directs us as to how the board should be established and as to its membership. We note, and I've been duly advised and informed, that in the previous submissions of the previous editions of the bill, there has been constant reference to the Jamaica Teachers Association by mere description, and the observation has been made before and submission made to the effect that we would prefer and think it in good practice that the Jamaica Teachers Association be named in the legislation. We know that there is precedent in other professional bodies where there are associations that are deemed to be representative of the majority of those sectors, be it the nursing profession, the engineering profession, and the engineering association. Their bodies, representative bodies, are named in the relevant statute. So we are again urging upon this committee and to the drafters that in the final legislation that the JTA be named specifically at section 1E of the first schedule, where by description it alludes to the JTA by saying that 6 registered teachers shall be on the board of the Jamaica Teaching Council, nominated by an association recognized by the minister as representing the majority of teachers in Jamaica. That description can fit no other entity but the JTA, so we would again urge that the institution be named. My understanding is that the JTA represents at this time at least 90% of all registered teachers in the island, and we believe that it would just be good practice, it would be prudent, it would be just, and for clarity that the JTA be named going forward. The next issue we've identified with the composition concerns, well, it can be found at section 10.5 of the first schedule, where it speaks to the quorum. The quorum should be comprised of 7 members. We have no issue with that. It goes on further to say that 4 of those members should be registered teachers. Given the state of the JTA, given its place in representing as I've said before, at least 90% of registered teachers in Jamaica. And given the importance of decisions that will be made and that they will directly affect the membership of the JTA in large, we would again ask that the JTA be included in the quorum, again specifically named as being present at every meeting, so that will aid in communication and good governance. We know that historically decisions are made at a particular level, and implementation is not as effective as it ought to be because of a lack of communication. So we believe that at the very outset, if the JTA has membership, not only on the board, representation that they are named, but that they be ascribed a seat of prominence by being named as a composition of the quorum, then that would do very good in moving forward, especially on the issue of compliance. So what we've discovered is that looking at the complaints procedure, we realize that there are 3 mechanisms, 3 avenues, 3 fora by which complaints can be brought, and the disciplinary proceedings arising from that. Namely, one complaint can come to the Jamaica Teaching Council, and thereafter the council might decide to initiate its own investigation. This is coming from at section 50 or 51 of the bill. And so the teaching council may initiate its own investigation upon receiving a complaint. It may refer the matter to the educational institution that is relevant, that quite possibly the teacher is aligned to, or it may refer the matter to the minister. We recognize that those provisions obtain now, whereby the relevant institutions do conduct their own investigations, and the Minister of Education will have latitude as well, coming out of the ministry, to investigate as it chooses to. And we have no issue with the council initiating its own investigations. Our concern is that there is no direction in the bill to suggest that its suggestion is that they all can be happening at the same time. So there could be some amount of duplicity. Not only would that result in a waste of resources, but it would be particularly onerous for a respondent who has to respond to 3, possibly, tribunals on similar facts arising from the same situation, quite possibly the same allegations being raised against that individual. We know apart from the time constraint, there will be a direct cost factor where it concerns representation. More important, so for tidiness, for efficiency, we believe that it is necessary for an insertion to be made to the effect that the starting of one investigation by any of these 3 entities will act as a stay, a bar to any further investigation arising out of the same facts, attaching to the same respondent. And more importantly, given that all 3 bodies have the same standing, the same level of authority in law, one cannot override the other. So again, we could be faced with a situation where there are concurrent proceedings, that different judgments or different decisions are made against arising out of the same facts. So that would cause some amount of confusion. So we believe that it's very important that one investigation commences at one entity, it acts as a bar to the other, especially given that there could be overlapping lines of communication and no clear instructions are given for that. Another issue we have is with the fact that at section 59.2, the council, the teaching council, has the discretion. I say discretion because the language there says may. The council may suspend the registration, license, authorization to teach, as the case may be, of a licensed or registered teacher or instructor who has been charged with a disqualifying offense.
You mean mean 59.5?
Yes. Okay, thank you. 59.5. Right, so that provision, which we are now familiar with, our concern there is that it could serve to, even though it is, as I've stated and we know, it is not a binding provision, it is not compulsory. We note that the council does have discretion in that matter. Our concern is that in the few instances, if at all, where it may be exercised, it would cause undue harm to the respondent, to the person who is awaiting the outcome of a decision by the council in this case. And we note that there might be constitutional concerns there, given that the suspension of the license, in this case, as the case may be, will pretty much bar the teacher from practicing during that period. So that person will be effectively being ascribed a sentence and punishment prior to conviction or determination of that matter. Another issue arising from that, outside of the possible constitutional conflict there, is that there is no, as we know, unfortunately, there's no time frame in which a tribunal, in this case the council, will have to deliver its judgment, is required to deliver its judgment. And so this teacher who is awaiting determination and has been suspended during that period might be in such a position for an inordinately long period. And to prevent that from happening, we would humbly submit that that provision be removed, especially since, as it says, it is not compulsory. And again, we believe that it was drafted like that because of the clear conflict with the Constitution there. So we move on to the fines section. As we know, the fines are noted in sections 24.2, 25.2, 26.2, and 26.3. And in those sections, a fine of up to $500,000 is likely to be affixed to someone who is found to be in contravention of these provisions, namely teaching without a license, pretending to have a license, obtaining a license by fraud or misrepresentation, aiding and abetting that same process, and giving false information to the council. Our concern, we have two primary concerns with how those provisions are laid out. First being that what is suggested by the fines, the same quantum being affixed to all three categories of offenses, is that they are of the same weight. And we believe that they are not of the same weight, and so the penalties that are fixed to each should match the offense, the seriousness of the offense. They should be proportional, in other words. And that concept is not foreign to the jurisdiction, and we find support for that in, for instance, the Spirit License Act, where we note that higher fines are attached to more serious offenses. So, for instance, you wouldn't pay the same fine if for opening a bar after hours as you would for operating without a license. Likewise, for operating your bar or your tavern as a brothel would be much lower than obtaining that same license by fraud. So we would urge that a similar pattern be followed. This is a well-developed practice that crimes should match, the penalties for crime should match the seriousness of the offense. We can think also of the fact that larceny, for instance, attaches a much shorter prison term than murder. And that is the same approach that we would urge in this situation. How the bill is drafted now suggests that teaching without a license, pretending to have a license, and obtaining same by fraud is of the same weight. And we do not believe that is good. That follows good jurisprudence. The second issue we have with how those fines, that penalty provision is set up, is that there is no risk liability attached to an employer for hiring or employing or engage in the services of an unlicensed teacher. Obviously, in circumstances where a license is required, as under this legislation. We are again informed that this submission has been made previously by this body, and we would urge strongly that it be reinserted. We consider that it would be a good show of partnership between the employer and the employee in this case, especially in circumstances where we are aware the government might be that employer. It would be a display of good governance if the government is in a position to abide by its own laws by ensuring that the persons it hires actually has the prescribed license. And again, we find support from legislation in the jurisdiction. So the idea of holding an employer liable in circumstances where he flouts the law, it can be seen in, for instance, the Road Traffic Act, Section 16, where it reads, a person shall, well, an excerpt of that, a person shall not drive a motor vehicle or on a road unless he's a holder of a license for that particular purpose. And a person shall not employ any person to drive a motor vehicle on a road unless that person so employed is a holder of a driver's license. And in such instance, the burden of proving that such a person, being the licensee or the would-be licensee, has a license shall be upon the person charged. So the obligation is discharged by the licensee proving that he in fact obtained a license, or as the case may be, had applied, and due to administrative flaws or delays, he just has not obtained same, but he has done everything within his power to comply with the requirements of the law. So with that being said, we make our proposal as to how we see that these provisions, sections 24, 25, and 26, can be modified to address our concerns as have been stated. So firstly, our recommendation made that at 24.2 or the comparable section, there be a fine imposed for teaching without a license and employing a person to teach who is unlicensed. And again, applying the principle of proportionality, we would urge that the current provision for 500,000 be reduced to 200,000. And again, applying the prescription that has been pointed to us in the Road Traffic Act, there should be some amount of proportionate distribution, whether jointly or severally, between the employer and the employee. So that $200,000 fine, the tribunal would make a determination as to how it should be apportioned between the parties. And also, a further recommendation to that is that that responsibility, that offense, well, the fine actually be paid to the tribunal, to the council directly, and not necessarily to the courts. We believe that that would fundamentally address two concerns. One, if the purpose of these provisions is really not to criminalize the teaching profession, which has been said many times, then this would be one clear way of doing just that. How the bill is drafted now, these charges would be made before a judge of the parish court. These are criminal proceedings that would follow as a result. So if this is not the intent to criminalize the profession, and this is supposed to serve as a method of compliance, seeking compliance with legislation, then we could also make this benefit to the profession, whereby we know that the council will be in need of revenue, has a direct revenue framework in place, revenue collection mechanism in place. So these fines should go directly to the council to the further benefit of teachers, rather than going directly to the consolidated fund. So in summation, what we would suggest, what we recommend strongly for section 24.2, the changes would be that the employer and the employee / licensee would be made liable under that provision, jointly or severally, so they would apportion the fine as it is based on the evidence who is more culpable in that instance, and more importantly, the fine should be paid to counsel and taken out of the courts. So naturally, the teachers would not have a criminal record arising from that situation. The other recommendation that we have...
Before you go on, Chairman, just a clarification. At 24.2, are you proposing a fixed fine or
Yes,
up
200,000, up to 200,000.
Up to?
Yes. So what I'm seeking to change is the maximum. As it's just to follow from how it is drafted now, it is up to 500,000. So it just be a replacement of the quantum. So as I've said, applying the principle of proportionality, we do not feel as if that teaching without a license is the same as obtaining same by fraud. And with that being said, it should carry a lesser penalty, a lesser fine. So our recommendation is to reduce that to a maximum of $200,000. As for the other offense noted at 25.2, pretending to have a license, we acknowledge that does indicate some level of moral decay or depravity. And so we would recommend that a higher penalty be attached to that particular offense, and recommendation is $300,000 in that respect. For the most egregious of the three categories, fraud, our recommendation is that that particular provision remain unchanged. So if I'm to recap, it would be 24.2, $200,000 shared between, up to a maximum of 200,000 being shared between the teacher and his or her employer, and for pretending to have a license, up to $300,000. Yes, the fraud provision remains unchanged, up to $500,000. We have no recommendation for any amendment where that is concerned. So moving forward to our last section, which is the ultra-virus provisions. And in this section, I'll be noting some parts of the draft legislation, which in our view is in conflict with existing laws, namely the Data Protection Act, the Disabilities Act, and our Constitution. So firstly, with the Data Protection Act, we know that at Section 21, there is to be a rule that contains information about instructors. And that information is really personal data. Your name, your address, your qualifications, and such. We also, further, at 22.1, the legislators, the drafters have sought to make a distinction between data which is made available to the teacher. So from the list in 21, which has maybe about 9 provisions, that list is reduced in a later section, and it is said that the reduced list will be made available to the public. It is not greatly reduced because all that is omitted is the address provision. So basically, everything except the address of the teacher that is collected will be made available to the public. The issue, we know that there was an attempt to reduce the access to that to personal data, but our contention here is that all the information collected is in fact personal data, and under the Data Protection Act, the Council, as the controller of that in data, has the responsibility to use that information only or exclusively for the furtherance of its functions as a regulator, and must act at all times as a custodian of that data, so the data is protected. All data which is collected is protected, irrespective of the fact that there are 2 sections. One section that is referred to as professional information, and the other one that is referred to as public information. So with that being said, we believe that if this legislation were to go through as it is, were to be promulgated as it is drafted now, it would run afoul of the Data Protection Act in several respects, namely that it would grant at Section 22.5 access to the public to the data which it has in its control, which it is mandated to protect under legislation. At 22.5, it says that the public will be able to inspect the registers, which again we're thinking is a physical register, but access is also granted online, and persons can get a copy at a particular price. They can pay to get a copy of whatever is contained in the roll or register. That's at 22.6. It also makes provision for the teachers to inspect the register. We have no problem with that, especially for verification purposes. The teacher or the person who has submitted that data under normal circumstances must be given an opportunity to verify that the information being held by the data controller is in fact accurate. So there must be access, but we would contend that that access must be restricted to the individual and not necessarily to your colleagues or counterparts. How 22.2 is presently drafted, where it is not very clear as to if teachers will have wholesale access to the registers, or it will be limited to the individual. So the amendment at that particular provision is that, or proposal is that that particular provision be a little bit more constrained to indicate that it will be just to your own information. 22.3 is particularly problematic because it encourages teachers to give access to a third party, in this case to their website login to a potential employer, so that person can log in and possibly verify their credentials. That presents a clearer data protection likelihood for a data security issue arising there, for hacking and such. And so to reduce that provision, that latitude should just not be granted, because usually what you find when a system is infiltrated, all files are accessed and not just one. And so that provision should be removed. More importantly, there really is no good reason for allowing your prospective employer to have access to your website, because in normal scheme of things, you would have presented a resume, and you can present those documentation on paper, which is probably an easier and more reliable way than granting access to a website and exposing the entire website, entire system to data security breaches. So those are our concerns as it relates to the Data Protection Act. We note other possible areas of concern with the Disabilities Act, particularly Schedule 4, the fourth schedule, which speaks to fitness to teach, might be in conflict. There's a possibility, and here we would just urge caution, there's a possibility that it would be in conflict with the Disabilities Act, rather, because at Section 1E of the fourth schedule, it says that in determining whether a teacher is fit to teach or has met the fitness to teach criteria, it should look at, among other things, a report or consider a report of a registered medical practitioner, which will indicate whether a person has, meaning a teacher, the applicant, has had any physical or mental incapacity or illness that will or is likely to interfere with the practice of teaching. That is of particular concern to us because it is just stated there without reference to anything else. And our proposal is that specific amendments or words be added to effect that provided that it is not in conflict with the Disabilities Act, in particular sections 24 and sections 25, which says that a person with a disability shall be entitled to the enjoyment of privileges, interests, benefits, however they are obtained, And also, there should be no discrimination afforded to that person. And this is particularly important because we think of how this might be able to change employment relationship over time. Disabilities or accidents, we're mindful of the high incidence of road accidents that occur annually. And any teacher could become disabled, whether partially or to some degree partially, whether severe or a limited degree. And so this medical report, what we're concerned is that this medical report might be reviewed without consideration for how it might offend or be unduly prejudicial to the teacher. So it says that they should consider the likely interference to the practice of teaching, how your disability or your illness will likely interfere with your teaching practice. Our recommendation is that whilst it should be noted that there is some level of disability, good practice would be, or good governance, or in furtherance of a more inclusive society, and what the Disabilities Act requires, is that where such limitation is noted by a medical practitioner, this is a responsibility of the employer to make the necessary interventions for that teacher, especially if that person was already engaged in the system, to function at their optimal. And it shouldn't be a question of just discarding or using the medical report to remove that person from the practice. So I move on to the final section. Again, these sections, we're noting different pieces of legislation that might be in conflict with the bill that we're considering. And usually how that happens, as I've been showing as I've gone along, is that particular provisions can be amended to save the overall bill. The offending provisions can be removed. When it comes to the Constitution, however, that might not be so easy. And our concern in this section is particularly grave, given that the issue we have is with the definition of teacher, which we know is in the interpretation section in section 2, right at the very beginning of the legislation. And it is really at the core of this piece of legislation. So if it is found to be in conflict with the Constitution, our submission is that the bill would not be, there would be of very little effect, or would not have the intended effect. Just to remind us of what section 2 says, that one qualifies as a teacher to be registered under the Act if they have essentially met 3 prescriptions. The first being that they have been admitted to an educational teaching program recognized in the country. Secondly, they have successfully completed a bachelor's degree or its equivalent, so it's a bachelor's degree or a first degree plus or in addition to a postgraduate diploma in education. And further to that, we're reminded of section 24, which says no person shall practice as a teacher unless that person is a licensed teacher or an instructor. So we have that before it's a very limited definition. And we've said this before. It bears repeating, however, in light of the fact that we are of the view that it might be in conflict with the Constitution. And one of the good things about law is that there's nothing new under the sun, and we can get guidance from, well, use of case law. I don't want to say errors of case law. And we are, at this point, asked to reflect. A few years ago, the government, through Parliament, made certain interventions by passing legislation to make the justice system more efficient by overhauling the court management system and replacing it with the court administration division. And what that did in that restructuring process, which is, I'm sure we know, recognize, is very similar to what is being attempted in this bill that is before us. The effect of that was that not only was a division named, an entity named, but also, more importantly, many persons were without employment. Well, not many, I should say at least one person felt that their constitutional rights were breached and they sought redress from the courts. And what is interesting in that is that in that situation, the legislation, by virtue of the legislation having been passed, the Public Service Commission, acting on behalf of the government in contracting with the public servant in this case, thought it fit to render the individual's employment to be terminated by virtue of early retirement. I say that to say that in considering that case, when it came up at first instance with Justice Sykes, then, who is now Chief Justice, he asked a very important question, which is the one before us today. And the question then was, can legislation be used as a guise to remove persons from employment without any kind of hearing or process, thereby gutting the protection given to the public sector, to public sector workers by the Constitution of Jamaica and case law developed over many years? As we know, this was the 2016 decision, and it further went on to the full court, which found that Ms. Patrick Gardner's constitutional rights were breached, and the court ordered her reinstatement. The matter was appealed, and only this year the Court of Appeal confirmed the decision of the Supreme Court. And essentially what we want to consider today, and again, I would urge us to apply some amount of wisdom in not making the same kind of errors, is that the court paid particular attention that in these circumstances, the applicant's right to natural justice and due process as are enshrined in the Constitution were breached. And we see that clearly if we're to consider how the bill was implemented. In those circumstances, there was no, well, let me read. The court had said that in circumstances where a decision, fairness will often require that a person who may be adversely affected by a decision will have an opportunity to make representation on his own behalf, either before the decision is taken, as in the passage of legislation, with a view to providing a favorable result, or after it is taken, with a view to procuring its modification, or both. So what the court found in that case, in citing for the applicant and reinstating her in her public sector job, was that how the Public Service Commission went about enforcing this legislation was to write her a letter to say you're being sent on retirement, early retirement. There was no discussion she was not given an opportunity to make any kind of concessions or proposals as to how this particular occurrence would affect her directly. And that is what we are faced with here. To direct our attention to the legislation, particularly sections 24, which I stated earlier, which says that she shall not practice unless he or she has a license. We, again, looking at the restrictive definition, we can clearly see that not the requirement for a bachelor's degree to enter the teaching profession and to retain one's status is a very noble position to hold. But given where we are in our education system, it would best be approached as a gradual process and not with the stroke of a pen, as was done with the previous legislation. The persons who will be adversely affected need to be engaged with. Another finding of the court was that if, again, we're relying on the principle of fairness and natural justice, you cannot give proposals to a matter when you're in the dark. So there needs to be full disclosure on what is the intent of Parliament in bringing forward this legislation. Is it really a means of sanitizing the teaching profession to get rid of persons who are deemed no longer useful because they don't have a bachelor's degree? I don't know about Thank you. So there needs to be engagement at all levels. Again, we're being guided by the legislation. As I said before in opening this section, we see not in very recent past where the passage, by virtue of the passage of legislation, which sought to overhaul a particular department of government, there were serious consequences for government employees. And as a result, the court held that those persons who bore loss as a result, in this case, loss of employment, loss of income, and a breach of their constitutional rights, had a right to redress, and they were successful in that application. So my urging to us today is simply that we do not go down the same rabbit hole expecting a different outcome. We could proceed, but the consequence would be far greater than with the legislation that I have referenced, because we have far more teachers who would be affected by this application of this very limited provision. I say that with the full knowledge that the majority of teachers in our basic schools do not have a diploma. And that is a fact. And so I'm not even going to stretch it to a bachelor's degree. And so the question is, how is the government going to seek to bring this bill into fruition, to apply this method, this bill in a fair and equitable way? Because that is what the Constitution demands, that it will be applied without injury to persons who are already employed to the government. And we just want to make reference briefly to the fact that where there is an existing, as happened, that is the case with the teachers in early childhood education, those who will be removed from this piece of legislation, they won't even have the dignity of being called teachers. That is the effect of it. They would have gone to teachers' college and have obtained a diploma and would be working, and possibly would have obtained a certificate in some other area, but not a bachelor's degree. And when they were hired, they were ascribed a title and given job descriptions. And as far as they know, based on their performance evaluations, there has been no question of their performance being anything less than satisfactory. Of course, in instances where persons are underperforming their provisions in every administration for remedial action to be taken. Our concern is when wholesale modification will be made to an existing employment contract without any recourse, without any reference to the employee. The employee relationship is a contractual one, and it's a very intimate one. And like with all other contracts, it cannot be changed. Fundamental changes cannot be made to it without reference to the parties. And if this legislation were to be applied as it is being prescribed now, or being preferred now, then without the proper intervention of the teachers, the early childhood teachers, well, all teachers who, when they were hired, did not have a bachelor's degree. Because what we need to remember is that unilaterally, the government as employer is changing the terms of the employment agreement by saying, now, when you were hired, you met the criteria because you had a diploma in X, Y, and Z. Now, that diploma is no longer the basic entry requirement. Well, that's all fine and good for the new entrants into the system. But our concern is with those persons who have already been engaged over time, as Ms. Patrick Gardner was, and others where unilaterally the employer is saying, you are no longer fit for this role, not by virtue of your performance, because you have been performing and that can be accounted for, that is well documented, but by the fact that we believe that, well, we don't even, the rationale is not important. The fact is that the requirement for the job is now being changed. And that's under every possible law, including the Constitution, requires that there be a fair hearing, that due process follows, and more importantly, the employee has a legitimate expectation that if he is performing the job for which he was hired, and there is no issue with that, he would be allowed to continue and remain in that job. What this legislation purports to do is by removing the title of teacher from the employee, that it's in fact a demotion in our minds. It gets worse in that they will know, in order to keep their job as a teacher, even though not being called a teacher anymore, they're performing the same functions as we know it, but in order to keep their jobs, they will have to now apply for an authorization to teach. When we look at the requirements for obtaining an authorization to teach, as stated in Section 29, and in, well, 29.2 lists those conditions, but particularly Section 29.2a says that the prospective employer, so the council will consider many factors when deciding whether to grant an authorization to teach. Because remember, you haven't met the benchmark requirement of having a bachelor's degree, so it's not a given that you will obtain same or you'll be granted that authorization. So in considering whether to issue an authorization to teach to the teacher who was a month before the passage of legislation was called a teacher and performing those functions, the council will now require of the teacher, no longer called so, the prospective employer will now have to indicate that the applicant is a person, or the prospective employer, this institution, must now state that the person, the teacher, well, sorry, the employer is unable to find a licensed teacher who is suitable to fill the position. So it becomes competitive now. And if you can think of a situation where all three of us are in an institution, prior to the passage, immediate passage of the legislation, we were teachers, but for whatever reason, and performing our functions well, I happen not to have a bachelor's degree, so now I have to interface with the council. The principal, dean of discipline, whomsoever, somebody from the educational institution must support my application for an authorization to teach with a letter stating that he or she cannot find somebody else with a license to teach. And that is the reason why they're going to offer me an authorization to teach. Now, bear in mind, we're not talking about new entrants. We're talking about persons who, prior to the passage of legislation, were deemed teachers and performing those functions. So if all three of us were in a department teaching, and they have, you know, just by providence, they had bachelor's degrees, they are now licensed with the passage of legislation, I am now in the unfortunate position, what if I cannot get this letter? Because, you know, the employer, again, is being expected to be honest when making this representation to the council to say that he has tried to find someone with a license, who is a licensed teacher, meaning someone who has a bachelor's degree, and he hasn't found that. So you will find that what I would expect is that the principal will advertise that position. And because if the prescription is that you should have a licensed teacher in that position, then I must try to fill it with a licensed teacher. Otherwise, I would be less than faithful when I'm making the declaration that I'm unable to find such person, which is why I'm now appointing or giving the opportunity to someone without a bachelor's degree to fill that position. So you will find that in those circumstances, for whatever reason or reasons, that teachers who do not have a bachelor's degree, who prior to the passage of legislation were functioning as teachers, will have that title removed, and they will be out of a job because they will not be able to get a simple letter from their employer stating that there is not someone else more suitable for the role. And there are many requirements under 29 that the applicant seeking an authorization to teach must meet. Another one, again, which supports our point that this will result in separation or a severing of the employer-employee relationship, is that C29(2)(c) says the council must now be convinced that the person has skills that are in short supply. Again, this is another requirement for obtaining an authorization to teach. Now, what if those skills are not in fact in short supply? You will not get an authorization to teach because we would not have been able to fulfill that requirement. But again, we need to bear in mind that these persons were functioning in the system immediately prior to the passage of the legislation. So if that is not a wholesale gutting of the profession, I don't know what is. So I would urge us in resting that we widen the definition that is before us to prevent this kind of outcome, and have particular regard for early childhood practitioners. I mean, what I would have appreciated is that there would have been some kind of plan being set forth to see what will happen, what is the intention of Parliament as it concerns early childhood practitioners, because it is not a secret that there are very few, if any, who hold the requirement that is now being held as a baseline. So what is the intention? What is the intended outcome for such persons if it is not meant to remove them from the profession? And if that is the intention, it needs to be done in a fair and equitable manner, because that is what our Constitution requires. Thank you.
Thank you so much. We have Member Rodriguez, then Member Miller.
Hello, it's working now. Thank you to the JTA for this presentation, and as you know, I have a special love in my heart for all of you. I'm a former teacher of mathematics, and I'm a child of a teacher, and I still have my JTA credit union account. Never shut it down, because yes, I am now. So I just want to say thank you so much for your, in good standing.
Get some interest.
So I just want to say thank you. It was thorough, quite detailed. I have a few questions and a few comments. And the first one is with the issue of the basic school teachers. On April 21st, I think it was, UE made a presentation here, and they made representation of that point. And I want everybody to notice something with our chairperson. She's making her own notes. She's not just relying on the recorders upstairs or on Mr. Nash. She takes it very seriously. And when that point was raised by UE, a lot of us sitting on this side also said it is something that has to be looked at. So Ms. Mowat, you made the point, and we just want to say we heard it, and we do know that it is something, because I went to a basic school in a little community, so I understand and appreciate, and I'm sure many of my colleagues on this side are on the same, and when I said this side, I mean all of us here. You know, really, so it's a point that we do take into consideration. I just want to state clearly the point made by Ms. Moore, the question raised as to whether this is the aim to get rid of certain teachers. As you can see, some of my colleagues were quite flabbergasted by that comment, because absolutely not. Teachers are the foundation of this society. What the aim of the legislation is to raise the profession to where it belongs, to heights of greatness like we have never had in Jamaica. And that is also the reason I disagree personally with the suggestion that we lower the fines. Nobody in this country should be allowed to practice fraudulently to teach our young ones, our middle-aged ones, or our older ones. So personally, I would not support lowering the fines, because it has to hit you where it hurts for you to understand if you are not legally allowed to teach, you should not teach. And if the fine seems high, in my humble opinion, there's a way to not have to deal with that fine. Do not practice teaching fraudulently. Then you won't have to worry about it. It's not hard to not commit fraud. And I understand where you're saying some sections, there are 3 areas you said, and some are not as harsh as the other. They're all supposed to be harsh, because they're all trying to stop someone from practicing in a profession that they're not legally authorized to do so. So I personally will not support that recommendation. Now, in terms of, I just wanted a clarification. Page 3 of your presentation, Ms. Mott, you mentioned the quorum. And I wondered if I'm not sure whether you meant that JTA, a representative from the association, needs to form a part of the quorum, or that the wording of this section should reflect that it's teachers from JTA who are forming the quorum. I wasn't clear. Sorry?
It's the former.
So it's that JTA should form a part of the quorum, the association itself?
That's correct.
So,
making
okay.
up the 7.
Right, so a representative of JTA should form quorum, not just the teachers who are there.
That's correct.
So that's what you're asking. Okay, and then in turn... I just want to say then, where you spoke about disciplinary action, I know we didn't handle the minutes from the last meeting, but in the last meeting of this committee, MPs Green and Crawford, who are both here, and Senator Ransford Braham spoke about this particular point. And Senator Braham himself raised the issue of, should it be that a teacher who is going through this disciplinary action, if at the end they are found not guilty, for want of a better term, then they should receive their salaries that they may have lost during that process. So that was something that was dealt with in the last meeting. And I think it may help. So it's on page 7 of our minutes from the last meeting, which we did, the ones Minister referred to earlier. So it is something that is under consideration, raised from the floor here of my colleagues. The next issue is the matter of fines. Well, I dealt with the matter of fines, but I just want to say, to compare a teacher and the work that goes into teaching the minds of a country to traffic fines or to a bar spirit violation is, for me, 2 completely different things. I think the bar for the profession of teaching and what it is in my mind is way above any of those. So maybe if we can find something else at that level, but I wouldn't compare them to traffic fines or to bar. The other thing is, I completely support your recommendation about an employer should be liable for hiring or engaging the services of an unlicensed teacher. I do support that point. It's not one that had crossed my mind before, and I think it is something worth considering. The other one is, you mentioned a violation of the Constitution. But what section of the Constitution were you referring to that would be violated? I may have missed it. You may have said it, but I may have missed. What section of the Constitution are you saying that this act violates? I would love to get an idea there. And do you think that the section you mentioned about fitness to teach, what if there is a specific list of doctors? It's done in some other countries where in order to, it's not just anybody going to their random doctor to get a letter to say, to look at whether or not they're incapacitated. What if there's a roster of doctors across the country that are certified by the ministry and they go into one of those for the certification? I'm not sure how and I wasn't clear as to how you saw the wording here where it says likely to interfere with the practice of teaching as violating the Disabilities Act of 2014. You had said 25 and 26 sections, but I wasn't seeing that as a violation based on my reading of the Disabilities Act either, because 26 and 27, I think, well, 26 and, well, 29, sorry, I think speaks specifically to that. So not 25 and 26, but 29. And I'm not sure because my reading of it is that it says interfere with the practice of teaching. So unless you're asking for it, something to be added to that to say if it is possible for some assistance to be given to the teacher to help through that, I'm not sure, but I'm just not seeing how it violated that act. But those are my comments and questions, but I'm most keen as to what section of the Constitution has been violated.
Okay, I'll take your questions in turn. Just to clarify that you said that you wouldn't personally support the reduction of a penalty for fraud. Fraud is mentioned at 26. Right, I'm just repeating. Fraud is mentioned at 26.2 as an offense and 26.3, obtaining a license by fraud, and fraudulent misrepresentation, providing false information to counsel. Our recommendation is that that provision remain unchanged. So you would be saying the same thing essentially, because it would, our recommendation that it would remain at 500,000 as it is now, as the maximum. And so I needed to clarify that because it would seem as if you thought I were suggesting that that be reduced. That's not what we said. In respect of the other offenses, yes, we do not believe. Yes, the principle.
No, sorry, going back to that point, I'm talking about 24 and 25. It's on page 7 of your notes.
But those don't speak to fraud.
Yeah, but to pretend to have a license, so pardon my use of the word fraud.
Oh.
One is pretending to have a license and one is teaching without a license. And they're basically the same, they're aiming for the same thing.
They're not the same thing.
No, I'm not saying they're the same thing. I am saying they're aiming to protect the same thing, which is an unlicensed teacher in the classroom. So they're aiming to protect our students from the same thing, having an unlicensed teacher. So one is somebody who pretends to have a license, they don't have a license. And one is somebody who is trying to teach without a license, they don't have a license. So it's the same thing that we're trying to protect.
But it's not the same as fraud, which is why
I withdraw the word fraud. I do withdraw that word and I rephrased just a while ago.
Chair, may I just make a comment on the... I don't know if we have not fully appreciated that you will have a database with teachers who are licensed. How is it, and I'm trying to find out, a teacher would be in the classroom teaching without a license, when there will be a database that will indicate clearly to principals and other persons that Garth Anderson is not supposed to be in the classroom. He doesn't have a license. How is that possible?
And that's why I support the suggestion from you all today, where you're saying what was the phrasing of it? An employer should be liable. So let us just use a random example of a private school. Let's just go with that for an example. And they hire a teacher without having checked that roster that you're mentioning. So that it is within that vein that I support the suggestion that you should not have a situation where the person is, but human nature things happen, so you have to protect.
So, Chair, if I may continue, the point is, therefore, we can't support that move and at the same time saying we are against reducing the fine. The two don't go together. Simply because there are other remedies outside of giving the teacher a criminal record. Why is it we are so hell-bent on a fine when you can remove the teacher from the list, you can suspend the teacher, you have so many other remedies. And should be hard-pressed, even if it's a private school. The Ministry of Education must have access to that database. So the private schools can't be out there floating on their own. So this almost fixation on fines is sending the wrong signal. It is not a kangaroo court that we are seeking to set up. It's a professional body that should advance the profession, should hold teachers accountable, but this accountability must be fair and just. We are not against accountability. Sure. But this fixation on fine is a serious
not our problem if you don't break the law.
I'm sorry, members. I move on to Member Miller. And Member Miller, you would want to?
Sorry, Madam Chair, she didn't say the Constitution. Where in the Constitution?
One minute.
There's a series of questions from Member Rodriguez, and I don't recall they have been answered.
Okay.
So maybe we should allow that set of questions to be answered, and then we can move on.
Right. We can't have that. Yes. All right. Member Rodriguez.
Thank you. Madam Chair, if I may.
Ms. Mowat, if you could answer the questions, please.
To what? Just a minute. Just let me conclude, please. You can add after. To the fitness to teach point and the Disabilities Act and the possible contravention there. We haven't said that this is a case where we can say definitively that it is in contravention. What I said is that I'm cautioning us that there is a likelihood for breach and violation of the Disabilities Act, and to prevent against that, words should be added because the council is now being directed to consider a report from a medical practitioner which highlights the illness or disability of a person, meaning a teacher, who is now disabled to whatever degree, how his or her disability or illness, could be mental, physical, whatever, is likely to impair his or her function as a teacher. And so when our concern is how will the council treat that? If all you have is this, now the only prescription to council is you must get this report. What do you do? So we believe that it should be tempered with something to the effect that, well, in evaluating this report, you should be mindful that no undue prejudice, you do not discriminate against such a disabled person, because that any form of discrimination, which is found in sections 24 and 25, speaks specifically that you should not discriminate against a disabled person, which is why those provisions were stated, right? And they should be allowed to retain whatever rights and privileges they had obtained through contract. Again, the employment relationship is a contractual one. So disability should not serve to sever or change those benefits that a person would have obtained when they entered that agreement, that arrangement. So that is why having a list of doctors wouldn't really cure, because it's not that these doctors are going to have any special skill. What we want is for the council to be mindful of how it considers this report that it will get. It will get reports, but what weight will it attribute to it? And then, even if someone, it's difficult to think of a blanket situation because disabilities are unique to the person. And again, it depends on what role you play within the institution. The fact that you're a teacher doesn't mean you have to stand all day for however many hours. You can teach from a wheelchair. You can teach on crutches, or you can teach on other forms of assisted aid. You could be blind and be teaching. So what we just want for the council to be mindful that the fact that you have a disability should not be a disqualifier in and of itself. And so whatever language that can be put there to direct our attention to those factors, that is what we're suggesting. A list of doctors wouldn't help. As for the constitutionality point, it is, again, this is a word of caution because, as we all know, I cannot say what will happen when this bill is passed in terms of whether a litigant will have a particular outcome before a judge, even if it goes back to Justice Sykes or the same full court as in the Patrick Gardner case, because the facts would be different. But it is very similar, and it is worthy of us paying attention because it's a similar kind of legislation which will have a comparable effect. As for the outcome, I cannot categorically say will be found to be unconstitutional, so I want to clarify that. But there is a potential breach, however, again relying on the guidance, the obiter dicta in the Patrick Gardner case, where there's reference to the due process clause of the Constitution. That's when we talk about fairness. The due process clause is section 16. And on the fundamental rights and freedoms and the Charter of Rights. And that is where I was making the point that any state actor has a responsibility to uphold the fundamental rights and freedoms of all citizens. And it is especially offensive when an agency of government or an arm of government would seek to be offending an individual's right to a fair hearing, which is why I said that if this change is to be implemented in the way in which it is being proposed through legislation, then there has to be discourse. That is what the Patrick Gardner case said, because the applicant in that case did not have an opportunity to sit with her employer, and for the issues, the case against her was not made. She was not told that there was the possibility that she would be removed from her post. So in like manner, we need to be honest with our teachers who are currently in the system, who do not have a bachelor's degree, to say to them, well, this bill is being proposed. It's likely to come into force in 1, 2, 3 years or by the end of the year, and it will have this particular effect on you, or it's likely to have an effect on you. We'll know you will not be able to teach without an authorization to teach. It will be very onerous for you to obtain same because you'll be competing directly with persons who have a bachelor's degree in whatever. And as a result, we would want to help you to retain the job for which you were hired. Anything less than that would be a violation of the employment agreement between the government and the existing workers, because they would not, and especially this is where the Constitution comes in, because they would not have an opportunity to be heard, to present their case, to present, for instance, I've heard it being said that, well, they should just go back to school and get a bachelor's degree. In many instances, especially with the technical and vocational trained areas, we're thinking of plumbing, carpentry, woodwork, you can't get a comparable degree in that. It's just ridiculous to think of that. For the theater arts, yes, you can obtain something from Edna Manley, but again, those programs are not fully in train. Some programs we understand are being developed. So you have a conflict whereby it doesn't seem as if the legislation, as it's being proposed, is in step with the realities on the ground. And that is where we would urge caution and we would say there needs to be greater intervention, there needs to be greater transparency to say, yes, you have a policy position, but how are you going to implement it that it is fair to the persons who you currently have in the system and who are performing? So there's no question as to whether they can do the function for which they were hired. The Parliament has just thought that they should get an upgrade. Well, we have no problem with that, but how do you facilitate them? Because you have a duty, because you have already contracted them as employees. So that is where there's a likely breach.
Colleagues, all good afternoon. I wanted to make the point regarding the differentials with the fines, in that an individual whose license has expired, whether deliberately or unknowingly, would be teaching without a license. And that individual ought not to be treated as someone who deliberately and actively set out to deceive and to retrieve a license. So the differentials are important. I would also be very, very upset and almost unnerved if my colleagues on that side, who are well-known trade unionists, would not recognize that there would be the need for reimbursement after an acquittal. The point, however, goes beyond that. The concern we have is that an individual may be on trial for years because the law does not indicate a timeline within which the hearing or trial or the outcome must be handed down. Right now, we have significant challenges with the Teachers Appeals Tribunal, where we have persons who are languishing for many years. We are asking that for the purpose of fairness, once an individual is on trial, then some consideration must be given for a residual income, and also a timeline must be established by the prosecutors for the completion of that setting. I also want to remind that the current legislation, the education regulation, gives a 9-month window for the completion of a case once the complaint has been lodged. The final point I want to make is that the issue of qualification, we have to recognize that there are some special creatures in education whereby the leveling stick of teacher education may not apply. And the issue of Edna Manley was raised. Edna Manley has persons who are excellent in their field. We could not find a teacher trained to play bass guitar like some of our artists. And they teach at Edna Manley. Because they do not have a first degree, it would make them ineligible to so teach. And for us, that would be a travesty to the system, because we would be eliminating the persons we currently call specialists, because they were engaged because of those skill sets that were not available. Yes.
Okay, member,
if I may
hold on, we have a lot of questions.
Okay.
Member Miller.
Thank you, Madam Chair. Thanks for the wonderful presentation. You know, some of the points, we disagree with, but we'll speak about it. One of the points that I'll like clarity on, I'll bring you back to the board composition in terms of having 6 registered teachers nominated to the board from a representing body sanctioned by the ministry that represent the majority of the teachers. That boils down to JTA, right? And the quorum of 7 members, 4 of which are registered and licensed teachers. What's the rationale for this? What mischief we want to achieve in regards to this? And then I'll clarify something else.
The assumption that 6 registered and licensed teachers amount to the JTA is not indeed correct or accurate. There are members of the teaching profession who are not members of the Jamaica Teachers Association, and they, in fact, would be classified or be in a position recognized as licensed and registered. And therefore, you would, by virtue of keeping the legislation as it is now, you would be cutting out a group of teachers who are represented by their union, which union represents more than 80 to 90% of the teaching cohort. So therefore, to leave it as just to say 6 or 7 licensed and registered teachers would be putting our members at a disadvantage.
Therefore, you have a follow-up question?
Just a next comment for something that was said in the presentation. Page 6, where fine is, an employer shall be liable for hiring or engaging in the service of an unlicensed teacher omitted from this version of the bill. It was stated a while ago that the employer is the Ministry of Education. We rightly know that sometimes the school board and the principal employ teachers without the ministry knowing. So what are you saying, that the ministry is still liable where that is concerned? Even some schools that our births are paid and the ministry knows nothing about it. I just need some clarity on this point, what was stated earlier. Thanks.
When a teacher is employed at a school, the teacher, that documentation must be sent to the Ministry of Education. Must be sent to the Ministry of Education for ratification. Whether it is done now or a few weeks later, if it is that the teacher is going to practice, whether it is a bursa-paid school or it's a fully government-paid directly, that individual must go to the Ministry of Education for ratification. It is not just at the domestic level where it is done and that's it. Because the ministry must be apprised so that the requisite funding can be made available to the bursa to remit compensation or for remuneration for the teacher so engaged.
Member Brown, Angela Brownberg, sorry. Yeah.
Thank you very much, Madam Chair. Let me thank the JTA for their very comprehensive and detailed presentation. I just wanted, first of all, to just say something about just how we have the conversation. When the entities at JTA come, we expect that some of the things that you raise will be issues that were raised by other groups. And so, I mean, I don't have to tell you who did come and say what before and what we said about it. We are listening to those issues where there's congruence or where we need further clarification. I want to thank you particularly for talking about that whole issue of the demotion and separation from employment and what could be one interpretation by members as to the real intent of the bill. Because at the end of the day, whatever we claim to be the intent is not really the issue. The issue is really what can be interpreted when it either goes into effect or when it goes before a court. And I want to thank you for that. The last time we had a conversation about why it is members in the teaching profession were so reluctant to embrace what the bill was trying to do. And I believe that in how you have framed the matter, you have made certainly one point very clear in terms of why some persons would believe that this bill is really not about professionalization, but it is about criminalization. Because what they are looking at is how it will affect them when it comes into being in terms of them being able to teach with the label teacher. I think sometimes we forget that an authorization to teach doesn't really mean the same thing as someone who can be called a teacher. And if it is that we are striving to put back that level of authority and respect in the profession, we have to understand these nuances as well. So I want to thank you very much for that. And I agree with you that this is something to be considered. Other groups had come and raised it, in particular the early childhood education sector. And I was saying to a colleague earlier, you mentioned one group, you know, like those in the arts and so on. But if we look at our early childhood practitioners, we know that what they are paid doesn't allow them to eat, take care of their bills, and then find money out of that to improve their professional standing. It simply does not. In fact, one of the groups, I forget which one, came and actually said that that is a matter that we should consider in terms of how we facilitate that transition and that improved qualification. So I thought the point was well made, and I agree with you wholeheartedly. I also want to agree with you about the penalties fitting the crime. And I thought that the example you used in terms of traffic fines were apt. I thought they were apt because there's a huge difference between, as you said not so long ago, an expired license that you are going to renew and having gone into the teaching using fraudulent means and deliberately trying to pretend that you are. And I believe that the idea of having different levels of fine makes sense. And I'm hoping that as we take the other presentations, that we on this side, meaning all of us on this side, will understand the importance of making sure that we separate the breaches and understand them for what they are and ensure that the fines are appropriate in that sense. I think that those were the two that I particularly wanted to raise at this point.
Thank you, Member. Member
Madam
Green.
Chair, if I may, just to respond to Member Cross, to say that we thank you for your the point you made, because you really understand what we're trying to bring across to this honorable committee. But I want us to go further in terms of definition of terms as it relates to who is a teacher. If we now put this bill into law today, it would in effect wipe out all the teachers we currently have with a diploma. It will wipe out all the specialist 1, the specialist 2. It will wipe out all the teachers.
Mr. Smith, I'm sorry. But
yes,
when you characterize this bill as doing that, you're sending a very wrong signal to Jamaicans. No. You are, I mean, this is the headline that's going to be out there on this bill. You're seriously, we're having a serious debate here, and you know that's not the intent of the bill.
Madam Chair, I'm not speaking
but when you telegraph that to Jamaicans and to other teachers, you know, I have to wonder, what is the message, what's the underlying message that you want teachers to get?
But, Madam Chair,
sorry, on a point of order. Chairman, I believe the associations that come before us must be given a freedom to speak their views. We, in the end, will decide what goes in the bill, but we mustn't constrain them if they have strong views. Let it be reported here.
Member,
we take it into consideration.
Member, the JTA is before us. They've been allowed to speak, but that does not mean that they cannot be corrected in terms of what they're saying.
But I don't understand.
They feel that they
your
are coming
view
to
versus
say
their
but that's
view.
not. But I'm saying that's not the intent of the bill, and this is something that they know. And to put it that way, to telegraph it that way, is to send a signal to the sector, to Jamaicans, about this bill that is not healthy. And I don't know that you could start out by saying, Mr. President, that this bill is important and far-reaching. It has the potential to transform the teaching profession. Those were your words at the beginning. Yes. But then you kind of kicked over the bucket by now saying that, you know, the intent of this bill, and if this bill is implemented, this is what it...
Madam Chair.
Sorry, on a point of order. I mean, Chairman, let us be clear. The Parliament make bills. The courts stand above us, are equal to us in interpreting those bills. We have seen, for example, with the NIDS bill. We have seen, for example, with the bill. The court had different views. So that while we parliamentarians may have one view, we should resist the temptation to tell our visitors, our guests, what is their view. Their view may very well find... Let me finish, please. Let me finish. Their views may well find accord with, what do you mean no, with the judges. So let me make it clear. I take offense to us trying to direct them what to say. They said that. Am I going to be allowed to finish, Chairman? Am I going to be heard?
Member,
Am I going to be heard? Because I'm not going to bow to the tyranny of the majority.
I'm sorry, Member Brown.
I'm not going to bow to the tyranny of the majority.
In terms of the order, Member Green is next in line.
No, I'm raising
you
a
are
point
behind
of order.
Member Green.
I'm raising a point of order. That's what I'm raising, and that takes priority. So, my point of order.
But be careful with your words.
Don't tell me what to be careful with. Don't tell me what to be careful
Of
with.
course I can tell you what to be careful.
You can, but I will ignore you because you are a new
Members.
So, Madam Chair, I'm making the point that we must resist the temptation to tell our guests what to say.
Can I? Nobody.
I am saying we must resist. Natalie, allow me to speak. I've allowed you that courtesy.
But you will not.
What do you mean you will not? That's the problem with the tyranny of the majority. I am not bowing to the tyranny of the majority.
Member Rodriguez.
I am not bowing to the tyranny of the majority. I am not bowing to the tyranny of the majority. I am repeating what I'm saying. We must allow our guests to speak as free. What is
Member Brown, please state. Member Brown, please state your point of order.
That's what I'm doing.
Not the argument, just the point of order. What is the point of order?
I am being interrupted by your colleagues.
What is the point of
I'm
order?
being interrupted by MP Crawford, Senator Rodriguez, and I'm saying I'm standing my ground. The JTA representative came here and they spoke in support of the bill.
What is the point of order?
That's what I'm doing. That's what I'm doing.
That's not the point of order.
I'm explaining my point of order.
No, you state the point of order.
I am explaining what is the point of order. And the point of order is that we must resist the temptation of interfering and telling our guests what to say.
All right. Member Green.
Thank you.
Chairman, Madam Chairman, I don't think I was finished, and I would respectfully ask if I be allowed so to do. Thank you. Madam Chair, I do understand your position, but I do understand that I, as a Jamaican, have a right. It's called the freedom of expression. And therefore, I intend to invoke that right. So
but
I have a freedom of expression, Madam Chair.
In a theater, right? You're not allowed to call fire.
Am I?
You are not allowed to call fire in a crowded theater.
I am reading, and I'm reading from the document. And I said before, and I will say again, if this bill, in its current form, is allowed to go through, definition of a teacher, as articulated in Section 24, says no person shall practice as a teacher unless the person is a licensed teacher or an instructor. It says a qualification to be registered as a teacher under this Act. 1, admitted to an educational teaching program recognized in the country, successfully completed a bachelor's degree or equivalent, or a first degree plus postgraduate degree in education. If this bill, as is here, it will in effect remove the person with a teaching diploma, the person who has qualification from the VTDI, the teachers who are, and there is still a remnant, though small in number, persons with certificate in education. And this bill, if is enacted as is, would remove those persons the minute it is signed into law.
Chair,
Go ahead, Member Green.
I wanted to start differently. So I will go to how I wanted to start, and I will come back to that point. But I do not like to leave points that are not factual up in the air. So I will come back to the President's point. But let me start how I wanted to start. Firstly, by thanking the JTA. I have had the experience of sitting with members of the JTA, and it has been, for the most part, an experience that I treasure, that I cherish. And we have had a robust debate as we are having today. And as such, I thank the JTA for coming, as they normally do with researched positions. And I think that is a good move, even though we may disagree. I would profess a lot of what I'm saying in relation to how I view teaching, how I view this act, and how I view what we're trying to achieve. I fundamentally believe that there is no profession more important than the teaching profession. It is a profession that creates all others. Teachers touch and shape the lives of the most vulnerable in our society. And because teachers touch and shape the lives of the most vulnerable, we have to hold them in higher accord. That is very critical. And a lot of what I will say will probably come from that place of how important, sacred, critical I believe teachers are. And not because my mother was a teacher, but just because it's fundamentally true that all of us sit here because of the work of teachers. I'll go to the specific points. I really don't have a difficulty with the proposal, Chair, that the JTA has made in relation to them being called by name. I understand why it is not normally done that way, because you may decide to change your name. You may decide, no, it's a reality. You may decide that you're no longer saying teachers, you're going to say the Jamaica Association of Educators. And if we say JTA, then we would have to come back to amend the bill. We would have to come back to, if we say in the bill that it is teachers registered to the Jamaica Teachers Association, and you change your name, we would have to come back. What I'm saying, however, is that I do not have a difficulty with what you have put forward. I do have a difficulty with what you have suggested in relation to quorum, unless I don't understand it. But what I understand you to be saying is that the quorum cannot be formed unless a member of the association is present. Chair, I strongly disagree, because if the association decides not to attend the meeting, you would not have quorum. And you could not rest so much power in an association, right? No matter how wonderful, glorious, how many teachers the association represents. So I would guard against that. I do not mind the suggestion of differentiated penalties. Again, I don't think it is a bad suggestion. There is a question whether you need to go lower with the fines, right? And I've heard you, or whether you need to go higher. It is up to. And again, I do start from a position that the most sacred profession is teaching. So if somebody pretends to have a license, should we be bringing that to no more than 300,000? Right? I am not sure whether we should bring it down. And I have seen the comparisons, but remember where I start from. Nobody is more important than a teacher, because the teacher is interacting with the most vulnerable. So while I don't mind the differentiation, I'm not, because remember, when Sir Hall speaks about circumstances, it is up to. What you're seeing is the upper limit. It's no guarantee that a teacher who is, let us say, found to be in the class without a license, that they would be fined 500,000. But I don't mind a differentiation, because I do take the sound point that there are nuances between whether you teach without a license, you pretend to have a license, or you fraudulently made a license. I hear the point about fine. I'm not sure it could be so designed. It's something to look at. It's something to look at. I won't go into that. I think we must be very careful. If an act under the bill is criminal, it doesn't mean that the bill is criminalizing a profession. There are acts that can be done in a profession that are criminal acts. And if you go into a classroom having presented a fraudulent document that you can teach, that is a criminal act. And it does, but we must stop saying that it criminalizes the profession. The bill does not do that. We must not say it, because it doesn't. It criminalizes specific acts that we all agree are criminal in nature. I'll continue. Very good point, Ms. Mott, about the Data Protection Act. I would ask, Chair, that we ask the Information Commissioner to take a look at the bill to see if it is in accordance with the Data Protection Act. I have my own views, but I think it would be good to get an external approach to that. Lawyers disagree, and lawyers disagree all the time. I respectfully believe that your submission regarding the unconstitutionality of what we're trying to do here is misplaced. And the case that you have used does not give rise to the points you have made. Very specific case where Deborah Patrick Gardner was retired in the public interest, in accordance with Section 125 of the Constitution. What the court found is that Section 125(3) says that she has to be given the opportunity to be heard. That's in the Constitution. She was not given that opportunity. If you look at Miss Patrick Gardner's case, Mrs., very interesting. She went on leave, came back, somebody was in her job. When she wrote about it, she was deployed. After she was redeployed, then she was written to by the Governor General, who said that she's been retired, not in the public interest, you're right. She's been retired in accordance with 125, but it could not stand up because they did not fulfill 125(3). The point that was made regarding the new Act 15A of the Judicature Act was not that it was unfair or unjust. It was that it was limiting the right of the Public Services Commission to consult widely by saying they should only consult with the Chief Justice. I say all of that to say that has no bearing on what we're doing here today. And there are a lot of precedents for professions to set standards whereby unless you're licensed, unless you have a practicing certificate, unless X, Y, or Z, Engineers Act, you cannot be called a lawyer, cannot be called an engineer, and that is what we're really doing here. Last 2 points. I think I've made a point, but I heard Garth, who I respect dearly, make a point about ensuring that we hold the employers accountable, and that if we do that, there may not be a need to treat with if the teachers were to run afoul, because how would the teacher reach in the classroom? But the reality in doing legislation, you have to take a 360 view. So I'm not saying you cannot or should not take the employers accountable, but you also have to put provisions in there for people who may run afoul of the system, because systems are human-made, human-run. So if a teacher is in the classroom without a license, yes, the responsibility can be on the employer, but I would suggest, God, the responsibility also must be on the teacher. And again, remember, sometimes when we speak about the act, we forget the children. It's not about the teachers all the time. It's about trying to ensure that our children are protected and are getting the best level of direction. Final point, Chair, I know I've been long. It is not factual, President, that this would wipe out teachers in the classroom now. It is untrue. Because provisions have been made for everybody who is now in the classroom, they can qualify under the Act. There is a designation under the Act for every single person, whether they have a certificate, VTDI, whether they have a diploma, they can qualify under the, and Chair and President,
please, about
I want you to listen to my words carefully. There is a designation under the Act that would allow everybody who is now in the classroom to continue in the classroom. So there would be no wiping out. So you do not repeat the definition of teacher to me, because there is a designation under the Act that everybody who is in the classroom now can fit into. So now, if the act was passed, remember, if the act is passed, you'd have to set the council, etc., etc. But if the act was passed now, all the people who are in classrooms providing instructions, there is a designation under which they could apply.
So,
let me respond, please, before you go any further.
Thank you, Chair. Thank you, everybody.
Please, please. I know the provision. I need to ask. The transition provisions, the Teachers Colleges Association made direct remarks in respect of the inadequacy of that provision weeks ago. So I can speak readily to it here. And I say it will not have the desired and intended effect as you've stated it, for the clear reason of the language of that provision in section 82 from my memory. It says that persons who are currently in the profession will be deemed to be registered. Okay, that's all it says. That does not give them the ability to teach. The Act clearly says to teach, you have to obtain a license. And that was a direct, but it doesn't require mere registration. And the transition provisions only allow for registration. And that point was made over a month ago, stating its inadequacy. Precisely. So that is the lacuna that we have identified, and I'm happy that we have the opportunity now to look at it more closely, to say that it would only grant registration. No one can teach with a mere registration. So what will happen? What will happen is, I've stated before, every teacher will have to approach the council for a license, because that is a requirement or authorization to teach. No, but the point, you need to listen, please, because what will happen is that the difficulty will arise, not because of the word registered, because that is the council has many functions. It issues registration, licenses, authorization to teach. Fine, so you're deemed to be registered. That's what Section 82 allows for. You make representation to council in order to get a license, so that you are not found to be in contravention of Section 24, which says you cannot teach without having a license or authorization to teach. Fine, so when you approach council, therein lies the difficulty which we've been trying to bring to all of our minds. Because the majority of teachers that exist now, irrespective of the attempts that have been made and are being made for those persons to matriculate to a bachelor's degree level, the fact of the matter is the majority of those persons who are now teaching don't meet that qualification when they're deemed to be registered. So we're saying, if the bill is passed as it is now, if tomorrow or next month, they're deemed to be registered, fine, they can't teach. Or else the teachers, the employers, if we have our way, would be in flout of the law. So how does the education process continue? How does it continue? They have to approach the teaching council for a license or an authorization to teach. We have many who will meet that prescription having a bachelor's degree. That will happen over time, however. So there will still be a period of dysfunction within the education system. Thereafter, we have a greater hurdle with persons who do not have a bachelor's degree in trying to obtain a license and authorization to teach because of what I highlighted earlier. Their employer will now have to certify that there is not a more suitable person who can be put into that position by virtue of the fact that that person holds a bachelor's degree.
Ms. Mowat, it is not true what you said about the qualification of the teachers who are currently in the profession. Very few teachers would not be qualified. Very few. If you look at the qualification now of teachers, I mean, maybe in days past, 10 years ago, 20 years ago, you only had. Yeah, go ahead.
Do we have Chair?
I heard, sorry, I wasn't here when the teachers' colleges presented. Are you suggesting that the transitional provision should not just say registration, but should also say authorized to teach?
Or licensed, as the case may be.
No, license may be a process. Okay, license may be a process. But the bigger point, the bigger point which I want us to, kind of redial the story on, is that we must all agree that there are provisions under the Act that all our teachers, that all the people who are in class now providing instructions, that they could find to continue, right? So it's not that this new act would abandon them, right? And I say this, I've spoken long, I'm finished now. I say this, Chair, because these provisions didn't just come out of thin air. These are some of the same provisions that the JTA advocated for. I'm telling you this for a fact. No. So to now kind of frame the conversation as if the teacher who has a diploma could not continue to give educational leadership in the classroom is just not true. They could continue. There would be a process through which they continue, but they could continue. Thank you, everybody.
Sir, Member Brown, do you still want to speak, or you spoke already? Or Member Crawford? Member Crawford?
I'll never give up the chance to speak.
Member Crawford.
Madam Chair.
But I don't know the JT's answer to Member Brown, but I'm certainly intended to speak.
All right, we'll come back to you, Member Brown, after Member Crawford.
Madam Chair, we must...
Okay, the President. Okay.
We must put things squarely on the table. The majority of our early childhood practitioners are not yet so qualified. But let's get back to the authorization to teach. Here you have a teacher with a diploma and is now classified as a trained teacher. But here you have a bill put into law that now reduce that individual from a teacher to an author, just to have an authorization to teach. Just being registered. No, but I hear the member to say they will register and be given authorization to teach. Well, I'm hearing that's what Member Green is saying. Okay, you see, I just want to bring that to the fore now. You made mention that they will be registered and there's a provision for authorization to teach. Am I correct in hearing you, sir?
There is a provision for authorization to teach.
But
I'm saying there is a...
But the process to attain that is where we are having some serious challenge.
No, but it's very difficult to have challenges with the process that hasn't really been established.
It's called foresight.
No, but again, the JTA will be a critical component in the establishment of the process, because how the board is structured the JTA, who will appoint 6 members of the board and will have additional membership to the board will drive the creation of this process. And I would expect, I would expect the process would be...
Point of information, Madam Chair.
I would expect that the process... I know the JTA's advocacy. I would expect that the process would be structured in such a way that would be the best interest of those in the classroom now. And the JTA, give me back the act.
Chairman, I don't know why Member Green is
so passionate about it.
No, just again the debate.
Is that teacher's son? Yeah, I'm finished.
Can we limit the crosstalk, please? Member Green, you're on the floor.
Again, I reiterate for all to hear. Member Green, the 6 members are not automatic members of the Jamaica Teachers Association. You're speaking to the composition of the board just now. And you said that the JTA will have 6 members there. But I'm submitting to you. No. It doesn't say the JTA. And that is why we're saying the JTA should be included. And I'm suggesting and submitting to you.
President, you would have a strong legal case if anybody else was consulted, if not the JTA. There's only one association. Only one.
Member, if it is not written, it cannot be said it is so. And there are members of the teaching fraternity who are not members of the JTA. And what I'm submitting to this body is that the phraseology of that item could say the JTA or any other group representing the majority of teachers of Jamaica.
Member Crawford.
Because the quorum could be formed without a teacher.
Member Crawford, hold on.
Thank you, Madam Chair.
Yes. You're next. You're next.
Before...
You're next.
Thank you, Madam Chair. Before I raise my concerns and comments, I just wanted to start by saying that the discussions, the crosstalks that we're having on this side, I'm a bit uncomfortable with it. I think that when we have joint select committees, the intent of the joint select committees are so that different persons can make their submissions, different groups, and when the groups come and they present, we're to ask our questions, and then as a group, we go back to look at the suggestions and make amendments to the bill. The composition of the joint select, we have members of parliaments, we have senators from both the government and both the opposition. And I think we come as one unit and we need to have a bit more tolerance, patience, and respect. That's the first thing I'd want to say. The second thing I'd like to say is that I agree that when the submissions are made and the different groups are here, we are to allow them the opportunity to make their presentations and to state their opinions. But at the same time, I believe that if an opinion or if a statement is made that is not factual, that the chair and other members have a duty to clarify. So now I'll move on to my points and my concerns. I want to thank the JTA for their very detailed submission. I would have read the submission before I got here, and on my way here, I was watching it live. I'll start with what I support and then raise the concern I have. So there are quite a number of points that I support. One, I want to place on record that I do support the call for the JTA to have representatives on the board, since the body represents more than 20,000 teachers, for the JTA to be named. I support that call, and especially as a teacher myself and from a family of 5 teachers. So I do fully support that call. I also support the call for there to be clear separation of the offenses and the fines. I also believe, I would have said it at one sitting, I don't remember who made the suggestion or which group raised the suggestion, but I do believe that when teachers are brought before a disciplinary committee if they have lost compensation or payments due to the time that the hearing was taking place. If any loss to compensation is there, that I believe they are to be recompensated, or they're to be compensated. And I also believe that we do need to look at holding the employers to some account. The concern I have, though, where it speaks to the composition of the board. Another issue with the composition of the board is the inclusion of a teacher who is registered and licensed and recognized for outstanding performance in education. The JTA's questions are: what qualifies as outstanding performance? Who determines who fits the description? I'm not sure what's the real issue that the JTA would have with that criteria, because we know what constitutes outstanding teachers, and as the body that represents so many teachers, and I'm sure you do know that appraisals are done. So I just want to know what's the difficulty you have with these particular...
Because the challenge we have is of twofold. Whose interest in the first instance, and who determine or who select that individual that will be so classified. So you're saying a teacher who is described to be as you would have articulated, but who determine who that individual will be? Who is going to select that person to be placed in this position to be making a determination on the future of a teacher to remain in the profession? Because the bill has not said who will determine who that person is.
Test one. Beautiful, you see? Yes, we have a challenge with just the composition in that context, because the JTA has employees who are currently not practicing, who do the majority of the representation on behalf of members. The structuring of this bill now would exclude the persons we have currently representing us at the Teachers Services Commission, currently representing us at the National Council on Education. These persons who represent us at the Appeals Tribunal would now be ineligible because they are not licensed teachers.
But if JTA gets its way with the recommendation to have a JTA named as having members on the committee, that would eliminate that concern?
No, it wouldn't. What we are asking in that context is that instead of saying persons from a body representing majority of teachers, we want the JTA named. In addition to that, we want the JTA to be able to nominate persons who are not necessarily licensed teachers to the board.
Okay. Member Brown.
Thank you. Thank you, Minister. I want to start by, through you, Chairman, expressing my condolences to the JTA and through the JTA to the families of those 8 teachers who have passed in the last week or so. And
I hear the number has increased by 1.
Sorry? I miscount?
I hear the number has increased by 1 since
whatever
today.
the number is, 9 or 8, our deepest and profound condolences. And I believe I speak on behalf of all the committee members in this. Member Crawford's approach is the approach I like, which is, as a committee, we listen to all of you, and we look at the bill, and we work with the technical team to make the bill better. I don't come here defending the exact clauses in the bill, because I've been through enough joint select committees to realize that bills are not perfect, and the transition to acts of parliament comes through dialogue, discussion, and listening. And that's the approach I come here with. And so I want to be clear, that I support the JTA being named in the Act. I believe one of the 61 regulations about public service as the Jamaica Civil Service Association. And as the submissioner said, almost all the other authorities, all the other bills relating to professional things, name their thing. Remember, Green, we can find a language which take into account any subsequent name change. But so I've seen enough bills where it is so written. So we are at one on that they should be named in the bill. And the JT has been such a profound part of the representation of teachers for decades that we should acknowledge that as we come to this bill. I also share their approach to fines. I am not one moved by this up to, because I see that while many of us in this chamber now are unmasked, I have seen cases of people in the country, in St. Thomas, in Kingston and throughout, who have been treated with this up to in what I consider an unfair approach, when I know that the Parliament had intended to go to tickets. So I am not moved by the up to, because the up to mean a judge can say 500,000 for the teacher who license expired on the 31st of December in any year. But on the 7th of January, in the new term, went to school, a teacher for 10 years, 15 years, and then get fined up to. I think we need to take into account those eventualities and protect for them. I also would love if the JTA could tell us if the bill is passed as is with definition of teacher in clause 2 or section 2, how many persons could be excluded relative to section 24 of this bill. Because that's what I understand the president of the JTA to be saying. And so it's not, Madam President, Madam Chair, that we can't fix it. We must listen to them, and if a fix is needed, we work with the technical team to make that fix so that our intent, which is not to exclude them, is covered. That's the approach I wish to take to this discussion. So I know, for example, it's not our intention to exclude the early childhood sector, but a lot of them would be caught in this web. We can fix it as a committee and recommend it to the full Parliament. And that's how I want us to approach this. Now, would the JTA have the view, for example, that those who would be excluded could be red circled, the former red circling, be allowed for a period? Grandfather is a term we use, so that we could fix section 82, which deals with the transitional period, to cover and accommodate these people. That's what this committee is about, and that's what we should do. So we can look at and consider as a committee whether we phase this out. Just as Minister, you as Minister will be able to set different dates for different parts of this legislation to come into being. So we could look at that phasing approach. And then the final thing, given the hour is late, I want to ask the JTA whether or not, in considering this bill, you gave any attention to the British situation, where the United Kingdom government had at one point having had a teachers council, as we are trying to do here, but they abandoned it after time. So I'm just wondering whether or not, from your connections with the UK teachers, if you could give us a sense of what led to it and how it has operated since. Because I need to take all of these things into account when I come to give advice and consent on a Friday or which other day the whip of the Senate chooses to call the Senate together. So I'd like to know these things. So I thank the JTA for your presentation. And I too am concerned. I don't necessarily, I'm concerned that it must fit within the Constitution. And that's the Attorney General's office to tell us if it does, even though they have told us sometimes and the court says otherwise. It must fit within the existing bill, be it data protection, be it disability, and we as parliamentarians need to satisfy that the formulations here are so. And that's why I read your presentation, and I thank you for it, because what you have done is to say to us, through your chair, be cautious as you go along, because in the end, the intent of Parliament is not decided by the parliamentarians. The intent of Parliament is when the people look at this cool thing down at King Street and say, you thought you did that? Well, that's not what you did. And so when I come to be part of a committee developing bills to send to the full Parliament, I want to make sure we cover those safeguards. That's why I'm here, and that's why I will hear all the time. And my colleague, Senator, let me put this way. Nobody can tap me from talk. If Stanley Red was here, he say, cut the pot out.
Member Gale, go ahead.
Senator Brown, is me you're talking? No. Chairman, thank you very much. You know,
just respond, Madam Chair.
No, man, you'll get a chance. You'll get a chance.
Okay.
You don't have to respond to him, you know. But you'll get a chance. Let me say this, Chair. Let me say this, because I believe that this deliberation is important. And the JTA is no surprise the extent of rigor you have brought to these deliberations this afternoon. And I say that because you are important stakeholders in the formulation of this legislation. And I've always been of the view that joint select committees are important where stakeholders must come and present their concerns. And I'm also of the view that if you have issues that are flagrant in nature, you must confront it. And when you confront it, you will get the response. Either we dispel the myth, either we take corrective actions in terms of what has been presented, or we treat with it. There are a number of persons on the outside who might not only be teachers, but might be watching and wanting to hear the concerns that are represented in the bill. And so you have had the opportunity to make that representation, and I think it's commendable. I want to start with an area in terms of the memorandum objects and reasons. And this speaks to regulate the practice and professional conduct of teachers and instructors and other persons to whom this act may apply. That is profound. I am not of the view that this bill is intended to sanitize teachers out of the profession. But guess what? If it's a myth, the myth has to be raised. If it's an issue or a concern, it must be confronted. Now, the area that speaks to in the first schedule about the composition, it says 6 registered teachers nominated by an association recognized by the minister as representing the majority of teachers in Jamaica, 5 of whom shall be licensed to practice as teacher under this act. When I read it, I just see JTA. I just see JTA. Unless you start losing your membership, which I think is rather unlikely. Right? But the question I'd like to ask is that you are a representative in other areas, in other commissions, in other groupings? Are you named? So that's something that we need to determine. If there's an alignment in your serving and representation in other areas, yes. Are you named? Huh?
Yes.
So that needs to be taken into consideration. Now,
Teacher Services Commission, we're named there.
My friend Clayton Hall raised a concern in terms of what constitutes Clause 59(5), where a registered teacher and unlicensed teacher and an instructor has been charged with a disqualifying offense. The council may suspend the registration, license, or authorization to teach, as the case may be held by the person until the determination of the matter. And I read this in conjunction with Clause 60, and Clause 60 spells out certain actions that may be taken. Yeah? What is absent from it is a critical one. So what happened if the person was acquitted? And as trade unionists, Mr. Hall, we always demand at the level of the tribunal that the individuals who would be found favor because of the judgment should not only be reinstated but to be compensated. And I think it's fair and reasonable in this case that the individuals must be compensated. And there should be a clause supporting that in either Clause 60 or somewhere else. So I think essentially that has to be treated with. In terms of the fine, and I think heavy weather has been made in relation to the fines. And I know that in my mind there's always a gray area where you either take corrective actions or punitive actions. Or, in this case, what it is suggesting to do is to propose criminal actions. But one of the things we want to do, we want to create the greatest deterrent in this case. The greatest deterrent. What I do support is that I believe in the registration there ought to be dual accountability. So the employer must ensure that there is that level of certification. And I can tell you why. Somebody might want to employ them friend. Or you may have situations where your family, and you know very well that there is no registration, no certification, no license, but you employ. So I support the dual responsibility. Now, the final point I want to make, and I've heard the declaration in terms of the definition as it relates to the qualification. And listen, we know that early childhood teachers there's a grouping, a community of interest. That is their entry to the profession. Yeah? And when they enter the profession, unless instructed, unless motivated or encouraged, some of them might not develop themselves. And I want to encourage development towards certification. But you are employed. You have been part of the system. And so, naturally for them, in seeing this, they would wonder whether or not I am going to be expelled from the system because of this legislation. And so, we must find ways to satisfy that particular concern so that there is the freedom of that fear. And if what it means is that we look at how we treat with the legislation to effect that confidence. So, I commend the presentation, and I know based on the process, all that you have said is going to go through another rigor with this team looking at the matrix with the technical team, and we may argue among ourselves again. And that is quite likely because of the energy that has been put forward by not only this group, but other groups. But I think the intent of this legislation is a good one for the profession. It's good for teaching. You know, I wanted to be a teacher, but I lost my way somewhere along the line and ended up somewhere else. So thank you, Chair.
So, Chairman.
Oh, Mr. Chairman.
Chair,
Mr. President.
I wish that in the response, there will be a response to the two questions that I left there.
Okay.
Yes,
Mr. President.
Thank you, Madam Chair. Just to respond to Member Brown, based on the information that I have available to me, we have approximately 2,000 basic schools. And of the 2,000 basic schools, 20%, which roughly means 200, would have one trained teacher assigned. So therefore, there are several teachers who are operating in the basic school who would have been so impacted. And based on the question you would have asked. To Member Gill, with reference to Section 5960, which you spoke so eloquently from, and I take your point, what I would want to have added to that, there must be a cap on the duration of the case or the hearing to ensure that it doesn't carry on in perpetuity. And we know our legal system. Thank you very much. Clayton will speak to that.
I think, President-elect, you
yes,
indicated you wanted to make a comment.
Thank you, Madam Chair. I want to beseech and to present and ask for consideration of the members of the Joint Select Committee that if we are indeed professionalizing this profession, and if the Jamaica Teachers Association, about whom you have all spoken so highly in high esteem concerning and our contribution to nation building is undoubtable and unquestionable, or articles of association that was articulated by our president today about our mandate to monitor and contribute to education and things education. History is replete with our contribution, the NCE and all these other bodies that are in existence that the Jamaica Teachers Association would have lobbied for their establishment. I submit to this Honorable House that due consideration be given to our request that a member of the Jamaica Teachers Association is present in the quorum for meetings. We are the body that represents the largest portion of the teachers. I do believe that we ought to be present for sittings. When it is that the council would have met, then it is that we would, I do believe that ought to be considered. Also, Member Gale, Crawford, and Brown would have, Member Gale in his utterance not too long ago opened the door about myths that are out there concerning the bill. And I think it would be remiss of us not to share one of the myths or one of the concerns concerning the absence of naming in the bill what the fee structure is going to be. That is a concern to teachers. Pardon me?
Would be in the regulations. No?
There can be in the bill a formula, not to state the fee, a formula to say what it is, and so that prevents any form of abuse or inflation or, just the moving of what this fee structure looks like. Based on what it is, how we are remunerated, we must take that into consideration. And the member did highlight that we are to bring to this room what are the myths that are out there, what are the concerns that are out there, and that is one of the concerns among our members, how it is that the fees concerning licensing, that is of great import to us.
Chair, Madam Chair, I just want to piggyback on what the President-elect.
I'm sorry, Mr. Anderson, I think, or Mr. Hall, was ahead of you. You will.
Thank you. Thank you, the honorable gentleman. Madam Chair, the point about the fees, I just want to reiterate how important that is, that a formula be placed there. And I heard in another sitting that it will be financed by subventions and all of those things. Those of us who operate in the public sector very well know that subventions can be removed, subventions can be reduced, and then the financing of this council will now rest on the shoulders of teachers. So that assurance in the bill is very, very important. I want to make the other point around what one member certainly does not like the term criminalizing. We should think carefully, former Minister, Junior Minister of Education, carefully that we do not give a teacher a criminal record for practicing without a license. That is really why we talk about criminalizing. Because the teacher is likely, if you can't pay the up to $500,000, you get a criminal record, and that's it for you. You cannot practice with a criminal record. And you don't have to get a criminal record when there are other remedies. I heard my colleague, trade unionists, mentioning that, we want the greatest deterrent. The greatest one, those of us who practice in education, is if you tell a teacher you will not be paid, you're cut off from the payment. That's the greatest. There's no need when you have other remedies. You're suspended, no pay. There is no need for the possibility, at minimum, of a criminal record. That is what we have a concern about. And if we agree that the employee ought to bear some of the responsibility who you employ, why is it there is need, some of the responsibility, why is it there is need to criminalize it? You must be caught. A teacher without a license, there are too many layers for you to get away with that. And you have other remedies other than a criminal record. Because if the teacher gets a criminal record, you're out of the system. That's it. The other, here and elsewhere, the other point I want to raise, we are not discussing, unfortunately, incentives. We have spent much of our time on punitive measures. There's nothing about a teacher who is performing and doing well. What will happen to that teacher? We are not discussing that. We are not even discussing what kind of support we are going to give to teachers to advance the profession, which is the intent of the bill. Much of our discussion is about who should sit on the board, what the fine should be. Is it 500,000? Is it 200,000? We so far have missed what are the concrete steps, things that will be done to advance the profession and to incentivize and to support teachers in order to ensure that the quality of education we provide is of such and is catering to all our learners and to the well-being of our teachers. We have not gone there yet. So we would have missed, in my view, the very intent of the bill, and we have steered ourselves down a road to talk more about the punishment. And we have to bring it because it is stated there. And so I'm wondering if we can now reverse to look at how we are going to really support teachers. We haven't discussed that. We haven't discussed that. And I'm talking about the law. What is written in the law specifically to support teachers, other than $500,000, 6 months in prison, and who sit on the board, and who, those are important. But to date, we have not gone to the heart of what the bill is about, unfortunately.
Minister, can I just ask a question, please, Madam Chair?
Yeah.
The question that Mrs. Harrison asked, you know, sitting here, I would say what she's asking for should go in the regulation. But is it possible that the team, the legal team, could answer that question so that at some point, you know?
Right. I don't think they can answer it right now, but we would certainly, right. So, Mr. Hall, I thought you gave up your time to Mr. Anderson.
Thank you. I want to make 4 very, very quick points, and I want to thank my comrade Gale for the yes. As a trade unionist, he will understand. my friend and the unionist, Mr. Gale, for the recognition of the issue regarding the compensation of an individual that has been out of pocket. But I would want to go further, and I'm sure Mr. Gale will agree with me. When an individual is on interdiction, as is the case here, while being tried by the council, for want of a better word, that individual should not be totally out of pocket. And if the license to teach is removed, if your license is suspended, and licensing is a prerequisite for practice, you are unemployed. And the law does not quantify a period within which this interdiction must be complete. And therefore, somebody could be on interdiction.
Clayton, we're with you on that. I don't think you need to beat that one no more.
So that if we look at all the things the Teaching Council is slated to do, it will be a very large bureaucracy. For the simple reason that you are to be licensing almost 35,000 teachers and maintaining those records and doing investigations and doing professional development. This seems to be a very large bureaucracy. And as such, the myth as to how it will be financed is significant for us. What we would propose is that a limit or a cap be placed on the fees for licensing, and that be placed in the registration. We put on the table 5% of 1 month's salary as a cap, because we do not want the bureaucracy to become onerous on the practitioners. We also propose that in addition, the section that speaks to the transition, that persons currently practicing be registered. We believe that the transition process must be clearly outlined.
Sorry, Chairman, just to clarify. Because as the minister said, this may be the headline. 5% of 1 month's salary every month?
No, not every month. That is fee for licensing.
Mr. Hall,
no, it's important. I will clarify what you said.
Let me say to members as well, the licensing period is every 5 years.
Yes.
It's not a monthly fee.
No, man,
that
and I am not proposing a monthly
yes.
fee.
Okay.
legislation, the legislation to indicate not just registration has a transitional process, but that all persons currently practicing must be given automatic authorization to teach. Because if you say
Mr. Hall,
yes.
I point you to the transitional provisions.
Yes.
In particular, clause 80. A person who immediately before the appointed day was registered under the Education Act as a trained teacher or an authorized teacher shall be deemed from the appointed day to be registered or enrolled, as the case may be, on the same terms and conditions as applied in respect of that person in the appropriate register role under this Act, and the registrar shall, as soon as practicable after the appointed day, enter the required particulars of the person in the appropriate register.
But Madam Chair, that section which you read gives rise to the concern. The section says the person will be registered or enrolled. It speaks nothing of being licensed or being authorized to teach. And that is the concern we have. Being registered does not impact your engagement any at all. The law will provide for a person not to practice unless they are licensed or authorized to teach. We are saying the transition clause should not only end at registration, but should also include a period whereby that teacher would be authorized to teach or automatically licensed so that the process will continue.
Just not to belabor the point, but again, the transitional clause deals with a period of time that the transition will take place. And it indicates that for that period of time that the transition will be determined, you will be engaged on the same terms. You know, it's very clear. So if you were a teacher before, you will be a teacher. No, it is not. I'm not saying that. I'm not saying that's what I wanted to say. I'm saying it says literally, by a literal interpretation of what is there, that you will be engaged on the same terms as before. Now, this is for the transitional period. And what it suggests is that when the law comes into force, there will be a transitional time frame. During that time frame, you can teach as is. That's why I so strongly opposed to the point about wiping out. And it goes on now. You would use that transitional time frame. So your service would not be bothered. But you would use my understanding, and clearly we're having a discussion, you would use that transitional time frame now to then make the requisite application. So the point is, the critical thing is, and I want us to be very clear, the critical thing is when the law comes into force for that transitional period, no teacher that was there before will be disadvantaged. It's very, very important that we communicate this to not just here, but to the membership of the JTA. Remember, the JTA is a union, and I love how President-elect put forward some of the things that these are concerns that come to you. You don't just take them out of a hat. These are issues that are raised with you that your membership expects you to raise, right? And I appreciate that. My hope is that you will also say to the membership that when we look at it, you will not be disadvantaged during this transitional period. You will have to, clearly, during the period, take some steps so that when the period ends, but during the transitional period, if the law were to be passed, no.
So I am in agreement with you. My concern is that I want the law to state that in the transitional period, the individual will be granted interim authorization to teach or interim license. If there is no objection to clearly putting it there, then let us put it there and we can be done with that. The other issue is that the period of transition is not stated. So we would also want the law to indicate, the current law indicates that you have 6 years as a pre-trained teacher. No. What I'm saying is, yes, madam.
I'll just ask our legal person to clarify that point.
Yes.
So we don't keep repeating what's on there.
Thank you, Chair. I just want to point the JTA to clause 81.3, which speaks to the matter of persons who, and I can just read, it says, this act does not apply to or in respect of a person to whom this section applies until, whichever is the earlier of the following, the expiration of a period of 12 months or such longer period as may be prescribed, during which the person may apply for registration and licensing as a teacher or authorization to teach under this section. So this clause allows for the registration, for the licensing within 12 months of the operation of the bill, of the act. Sorry.
Well, Madam Chair, you see the more clarification is provided, the greater my fears. The current law provides for a pre-trained teacher to be given 6 years to attain qualification. The 1 year period, let me just be clear with you, no program of study in education lasts for a year. When a law is passed, the simple act of being enrolled will not happen until the next academic year. By that time, 1 calendar year could have passed. What we are seeking is a guarantee of a time which is similar to what currently exists in a law or the ministry's policy, which grants a period of 6 years to pre-train teachers as long as they prove the attempts to improve their qualification.
Minister, can't we take that under advisement, look at it, because I think it's an important, point being made, and I don't think we are in disagreement with them. So again, it's about how we fix the legislation to take into account these points being raised, legitimate points being raised by the JTA.
2 final points, Madam Chair.
Still have you gone?
Yes.
Mr. Hall knows
quickly.
that there are not very many pre-trained teachers in the profession.
True.
He knows that very well.
Except at the early childhood level. However, 2 very, very quick points. The first one, it is important for us as a union, how we operate, to ensure that persons who are not licensed but appointed by the union will have the opportunity to sit on the board. Teachers are defended by persons who are no longer practicing and licensed. And it is to ensure that they have this representation that persons like myself would be allowed to sit on the board on their behalf. Because under the context, I may not be a practicing teacher and be licensed. The final point I want to make, persons like Dr. Nicely, yes, not me, Dr. Nicely. The final point I want to make, Madam Chair, and it is something that I would want us to think about, not necessarily to respond in this concept. If our aim is to professionalize the teaching service, I put it to you that this cannot be achieved by having non-professionals manage, govern, and determine the direction of the profession. No other profession in Jamaica or elsewhere where there can be a quorum set up without the professional being present. None other. When you look at the quantum of the persons on the board of the teaching council can achieve a quorum without 1 member of the union representing teachers being present.
Mr. Hall, Member Green already made that point.
Yes.
There are no restrictions on members showing up to meetings, right? But if allowed to form part of the quorum, you could hold the meeting hostage.
It goes beyond that, Madam Chair. It goes beyond that. The point I am making is, for a profession the professionals must have superior voting power in that board. What we are... No, the truth is, when you look at the composition of the board, interests that are not teachers' interests can outvote teachers every day, and that's a problem.
But remember, Mr. Hall, there are other very important stakeholders in the education sector
I agree,
that have
but
to
those
be represented.
Yes, I agree, Madam Chair. I apologize. But sometimes the emotions run high. I agree that there are significant other interests, but these interests should not outvote the profession in professionalizing the profession.
Just to make a point, Madam Chair, the association does not the profession make. We have to be very careful about that. The President has said that there are teachers who are not members of the association. The association does not make the teacher the professional. The quorum is made up of a majority of teachers. That's what it says. The quorum is made up of a majority of the profession.
Right. So let me...
Chairman, I just want to say that I understand the JTA point, but giving the JTA a veto power would require a lot more convincing. Because I recall there was a time where there was a body that required a quorum being formed by a certain organization, and that body didn't meet for a while. So I need more convincing on the veto power. But the question of a majority of teachers, yes. But the veto power, you need to convince me a little bit more on that.
Madam Chair, if I just make a point on...
And I just want to say... I think the Chairman, I think the youth, it was the UWI who raised this point, I believe, as well.
Madam Chair.
All right, so we're against time, Mr.
I just want to make a brief point that one of the things we must not miss in the discussion is that we are setting up a professional body. And therefore, the majority of those on the council must be teachers. If that is not the case, then it is not really a professional body. So that must be considered seriously. What we would have is just another council to try teachers, whether or not they would have missed professional standards. So we can't miss the important point that, like every other professional body, the professionals who come from that particular profession must have superior presence, and no quorum should be formed without the majority being teachers. At minimum, that must be considered seriously. So I am making that point because there has been other discussions. If I'll just be allowed as a guest to make my point, I would really appreciate that.
Yes, please finish your point, Mr. Anderson.
So I'm making that point simply because recommendations have been made here as to who on that council should have final say, final professional judgment on professionals, whether or not a nurse, a lawyer, a doctor should be part of that final decision to make a professional judgment, which is critical. And that's part of the concern of teachers. Who makes the final professional judgment? If that is not the majority of the teachers, we are not making a professional body. What we have is just another board. Like we have now, persons who don't know much about education, have a sense of education, may have been teaching, left. They went to school, but they turn up like some of your boards, Minister, you know you have some challenge with. and then we end up to tribunal and to the court to settle the matter. This is nothing different if we are not making that distinction.
Okay, thank you so much, Mr. Anderson. Let me thank all our thank all our members. I see the president-elect. Okay, final
Thank
comment.
you, Madam Chair.
Yes.
I approach again through the door open to me, read the myths that are out there concerning. And one of the questions I would like for this committee to consider is, and to deliberate, what is the impact? What impact will this license have on the tenureship for teachers? Because many teachers have that as a concern.
What do you mean? What do you
don't
mean,
understand.
madam? What do you mean? Yeah, what do you mean by that?
You're permanently employed,
Yeah.
leave facilities, all of the benefits that have been that are tenured based, and the license will be every 5 years. So what happens to how we currently obtain and what we consider to be a tenured position? How will this bill impact same?
Okay.
Because services may just be interrupted.
So, all right, we'll take that question when we go to deliberate as a committee with our professionals. We will take all that you brought here this afternoon to the table. So I want to thank all our members. I want to thank the JTA for a robust discussion this afternoon. You brought your issues to Parliament. We listened, we've taken notes, and certainly in our further deliberations, there will be consideration, and members would have already indicated their approval, if you will, if I can use that word, of some of the issues you brought to the table. We can see where some amendments need to be made to some of the different clauses in terms of what you've raised. I just want to remind us that this bill was recommended in 2004,
Yes,
again in 2009, again in 2021.
and again, 2025.
It's gone through many consultations, many iterations. When we got to the point of having a draft bill, we could have just, as a government, we could have just come to Parliament and passed it. But we decided to open it up to a joint select committee, even though, yes, even though it would require more time in the making, but we felt that going through this process of deliberating and hearing from major stakeholders, that it will make for a better bill. And I certainly see that. So
Chairman,
I want to thank you so much.
Chairman, I'm just
Yes.
wondering, are you talking about the Occupational Health and Safety Bill, or I could name a number of other bills that has gone through the same process? This is not a favor to anybody we're doing, We're simply saying we as a Parliament have a duty to hear the stakeholders, no matter
No, but
how long,
that's, so
no
what's
matter
the
how long
point,
it took the bill
Chairman?
to come here.
No, you are, I'm making a point. I'm making a point just because of the length of time
Yes.
that this bill has been around and the many consultations that it would have gone through over the years. JTA itself has signed off on a bill, but in our estimation, members, this is such an important bill that we had to bring it to a joint select committee to allow members again to come with their points so that we can hear those and we can incorporate as many as we can into the bill to make it a better bill. And I believe, based on the presentations that we have heard, not just from the JTA but others, this bill is going to be a better bill than the one that we brought before the Joint Select Committee initially. So I want to thank members for your contribution, for being here until this hour. Thank you so much, JTA.
Madam Chair,
do you have a last word?
Yes, Madam Chair.
All right.
Before I say thank you.
Oh, I'm sorry. Could I just have Ms. Shortland, you wanted to say a word? Let Ms. Shortland, our legal person, say a word before you come in.
Thank you, Madam Chair. Just to raise 2 points in relation to the transitional provision, Clause 81.3, which, even though it gives a 12-month period in which the person will be allowed to teach and thereafter apply to be licensed, the minister has the power to extend the period because it says prescribed. So by regulations, that period, based on the circumstances, can be extended. Secondly, no one would be excluded from the profession because until you get your qualification based on, I think, what will be an amended definition for teacher, until that period, you can get your authorization to teach. So you would not be excluded from the profession.
We would like to come to an end here, and Mr. President Smith, unless you're going to say thank you.
Madam Chair.
I will move to close.
I wish to thank you and the members of this committee for allowing us the opportunity to ventilate some of the issues that we have. We listen carefully, and we are anticipating that when not the final, because we want to have an opportunity to review again before we reach that final stage. But when we come there, and I hear the minister to say that we started in 2004, and I'm anticipating that as we move further, we'll get it closer and closer until we get it right. But again, the Jamaica Teachers Association, thank you very much for allowing us the opportunity to speak from our side and our vantage point on the issues that we have and we continue to face. Thank you.
All right, you're free to go. Thank you. Members, somebody move for the, so moved? All right. Okay, next date, Mr. Nash, we have a next meeting date? The 31st of May. Where is it, Mr. Nash? Okay, the next... Yeah, the next meeting date will be Tuesday, May 31st at 10 a.m. Who will be presenting? Huh? Okay. Okay, yes, Tuesday, May 31st at 10 a.m. Thank you so much. Yeah.
What you can do now, you can use your glue as a guide to where you're going to stop. So what I'll do, I'll take the brow